All right, so we are now recording. We're going to get started. My name is Rebecca Thistlethwaite, and I'm the director of the Niche Meat Processor Assistance Network. We're an extension community of practice that helps small-scale meat processors thrive. We're housed at Oregon State University's Center for Small Farms and Community Food Systems. Today's topic is called Know Your Rights, Understanding USDA, FSIS, NRs, and Navigating the NR Appeals Process. So NRs are written by inspection staff when they think that you're not following the rules, and there is something you can do about it. So we invited a couple speakers today to talk about what NRs are and what the process is of appealing them and cleaning up your record. So we're going to start off today with Dr. COL Fisher. He had decades of experience working for FSIS, and now he lends his time to helping processors navigate regulatory compliance, and he provides a lot of wisdom and experience to our community through our listserv and working one-on-one with processors. And we can't thank him enough for the value that he brings to this community. Following Dr. Fisher, we're going to move on to Dr. Denise Perry, who is a meat scientist and plant manager at Lawrence Meats in Minnesota. She's also a newly appointed member of the National Advisory Committee for Meat and Poultry Inspection, NACME. And she's going to give us more of a boots on the ground personal experience of how they deal with NRs in their plant. So with that, I'll stop talking and stop sharing my screen and pass the mic over to Dr. Fisher. You can share your screen now. And you should unmute yourself too.
Okay.
There you go.
Okay, now I'm unmuted. I hit the wrong button.
No worries.
So good morning, everybody. I see a few familiar names there in the chat list. So let's get going. All right. Start my little timer. Okay. Let's see. All right. Okay, well, skip the title. Whoops. Come on. Okay, so before we talk about how to deal with an NR, it helps to understand a little bit what an NR is, all right? And it's very important to understand that federal inspection of meat and poultry products is a legal process. It's not just some administrative method that exists outside the law, all right? It's a legal process. All the legal rules apply. So the NR is an official record, all right? It's a legal document. It's created and stored in what is called the Public Health Information System, or what you will hear inspectors refer to as PHIS, all right? It documents official findings. What is in PHIS is the official record, all right? And it's accepted as true unless proven to be false. And it provides that record. It goes on forever, all right? And it provides a basis for further enforcement action. So don't just think that you can ignore an NR that you got last week because the inspector no longer brings it up. FSIS at a higher level can bring it up later on as part of an enforcement action. So you want your compliance history to be accurate, all right? Now, there are procedural rules for creating an NR and how inspection personnel document non-compliance. And you'll find those in FSIS Directive 5001, right? And it's useful to be familiar with them, because if inspectors are writing NRs and not coming close to following this procedure for creating an NR, then that's one reason for appealing or pushing back against the validity of the NR, all right? Now, you basically have three ways to respond to an appeal, all right, in PHIS, all right, or on the official record. You can go into PHIS and you can accept the FSIS decision. And if you own the NR, if the NR accurately describes what happened, all right, and you fully agree with what is written in the NR, then there's nothing wrong with accepting the NR decision. If there's anything you don't like about that NR, you can appeal it. You may not be appealing the NR and asking that it be removed from PHIS. You could simply appeal the NR and say that the information in the narrative is inaccurate, all right, and you want it changed, and you say what you want it changed to. Most people appeal an NR because they completely disagree with it and they want it removed from PHIS. Or you can literally do nothing. There's no requirement to accept or appeal an NR. But just remember, if you do absolutely nothing, that NR is part of your compliance history and accept it as true. So there are also procedural rules, all right, or internal, instructions to FSIS personnel on how they respond to an appeal. And you'll find those in Directive 13,000.3. And again, our purpose is not to go over those, but it's useful to be familiar with those. Because if they don't respond to your appeal appropriately, then you have a reason to elevate your appeal to the next level, all right? They can't respond to your appeal simply by ignoring your appeal. In other words, they don't have the option to do nothing. So why and how do you appeal an NR? All right, well, why? I already kind of touched on that. There's some sort of factual inaccuracy. And how? You can appeal verbally or in writing, right? Well, it's a tenet within FSIS that if it's not written down, it didn't happen. So I would tell you, verbally appealing an NR or verbally talking to FSIS inspection personnel about some action they're taking that you disagree with is sort of like the football coach arguing with the referee. It's really not going to get you anywhere. The best way to deal with an appeal is in writing, because when you correspond with the federal government, that becomes part of the official record. Your grandchildren can find your appeal in the National Archives in 100 years. But how you put your appeal into writing matters. If you put it in a letter and put it in the mail, you have no way to, it's basically impossible to know that they got your appeal. So if they want to ignore it, they'll ignore it. If you put it in an email, you often run into the problem of they don't get it because the security settings on federal email systems tend to shut out or automatically put emails from Yahoo, Gmail, AOL, all of those third-party systems directly into the spam folder, and they just don't see them. So the best way to respond to an appeal is in PHIS. And to respond to an appeal in PHIS requires that you have a PHIS account. I'm not sure if I put a slide in here how to deal with that, but if I didn't, we can deal with that later. Okay, apparently not. So when you getting down to the actual appeal of an NR, check the time. Okay, doing good. FSIS has the burden of proof, right? And the standard of proof is a preponderance of evidence. So for your appeal to, or for your NR to stand, FSIS has to prove that a noncompliance exists based on a preponderance of evidence. So when you appeal, what you need to do is essentially show more evidence for why the noncompliance does not exist. Now, when appealing an NR there's sort of a method to it. Now, the method I use is I start out with block 6. In block 6 are the regulations that you allegedly are in noncompliance with. And so I literally copy and paste the language from those regulations onto a piece of paper. And so I have them right in front of me. And then I take the narrative in block 10 and I copy it on that same piece of paper. And then what I do is I compare the regulatory requirements for the regulations in block 6 with the information in the block 10 narrative. And I take what are the facts in block 10, because often what is in block 10 is just opinion or suggestion or innuendo, and they're not actually facts. And so I identify the facts in the block 10 narrative against the regulatory standards from block 6, and I see if there's enough information there to justify the NR, or if it fails to support the NR. And then I use that comparison to refute the NR, and then I end the appeal by clearly stating what outcome I want. Do I want the entire NR removed from PHIS? Do I want one or more of the regulations cited in block 6 removed? Do I want the text modified? Do I want to add additional facts? Right? Okay, an example. All right. I forget what whoa, I'm moving my mouse here. All right. Just a second, I had to jump forward. I should have looked at this before. All right. Okay. All right. Come on. Whoops. You can tell I'm not real good at doing these. Okay. An example. We're going to run through an example of an appeal. So on this this fictitious NR in block 6, there are three regulations cited as relevant. This is what they are: 38165G, and that's what it requires, 41613C, 416.4D. All right, and you can see what those requirements are. So this is the description of the noncompliance. So while performing a walkthrough in cooler number 2, hair and other unknown substances are observed on the ribs of a lamb carcass, all right? And hair is observed on a COL fat in an open, unlabeled blue plastic tote. So basically the inspector walks into the cooler and sees inspected and passed product that is being held in the cooler and sees hair on this product. So I'm gonna back up and we're gonna look at, okay. So now we're gonna compare those block 6 regulations to that block 10 narrative. So the first one, 38165G. Well, that's a poultry regulation, all right? And this establishment slaughters livestock, sheep. So 38165G does not apply, all right? And that is the reason in your appeal you would want 38165G removed from block 6, because it literally does not apply. And you'd be surprised how often that happens. Poultry regulations get cited in noncompliances for livestock establishments and the other way around, right? So we've dealt with that one. That was pretty simple. 416.4D, all right? That requires that the establishment protect the product from adulteration during storage, all right? Well, the establishment slaughters lambs under traditional inspection. And under traditional inspection, the inspector is responsible for directing all trim. So if this hair on the carcass was of sufficient significance to prevent that carcass from receiving the mark of inspection, the day before, the inspector should have required that hair to be removed. This hair is now allegedly some of that, that little incidental hair that you find on a carcass. And I'm gonna back up a second. Notice in the narrative, it just says hair, all right, that was seen on a carcass. That could be one hair, that could be 1,000 hairs, all right? In our case, I don't really say so, but it's just a hair or two, all right? It's that incidental hair that you can probably find on just about any carcass, livestock carcass, in a cooler if you look, all right? So the product described was not adulterated during storage, all right? 416.4D requires you to protect it from adulteration during storage. Well, this hair got on the carcass as a result of the slaughter process. So this carcass was not adulterated during storage. So arguably, the narrative does not support 416.4D noncompliance, all right? So you can argue that 416.4D does not apply, right? Now, the last regulation, 416.13, all right? Well, that requires that the establishment monitor the implementation of its SSOP procedures. The establishment's SSOP doesn't describe a procedure that addresses a nonconformance hair on an inspected and passed carcass, all right? And 416.13 does not require that the SSOP includes such a procedure. So again, the cited regulation does not apply. So the applicable regulation for this narrative is actually 318.2, all right? The inspector is performing a reinspection of already inspected and passed products. And when an inspector performs such a reinspection, they're supposed to use a statistically sound sampling plan to determine if the nonconformance, in this case the hair, rises to a level of adulterating the product. So finding one hair on a carcass doesn't rise to the level of adulterating a product. Finding hundreds of hairs, different story. But in this case, the inspector doesn't allege 318.2 noncompliance, nor did the inspector describe examining these carcasses using a statistically sound sampling plan, which is the regulatory requirement. So based on these four facts, all right, there's evidence, you would appeal the NR. And I think I went through that in just about 20 minutes. So I say thank you. And I will end my slideshow.
Thank you, Michael.
I've lost my Zoom there. Oh. Anyway, I'll get my thing muted here in a moment somehow. Stop share. There we go.
There you go. Excellent. Okay, so we're going to save questions for the end. So if you had questions for Michael, feel free to pop them in the Q&A box, and I'll make sure to get them after Denise. And with that, we're going to let Denise share her screen and give her presentation.
All right. Hopefully, can you guys see it? I don't have my...
Yes, we can see it.
Okay.
Just put it on present.
Yeah, I got to get my presentation part up. Okay. So I will be covering, overlapping some of the points that Michael has made. we didn't work on these together, but they seem to mesh well. So I'll be giving a bit more of a direct example and just my own personal methods of handling NRs within our facility. I don't do it as hands-on now as I did previously. Every plant is going to have a very personalized way that they want to handle this. It really does depend on your relationship with your inspection staff on how you do that. We have a fairly good relationship with our inspection staff. It doesn't mean that we don't disagree. And sometimes it requires a breath before response. A lot of times our inspectors will come to us and let us know when they're about to issue an NR. And so Michael kind of talked about a verbal appeal, and I have probably, I didn't think of it that way, but I've probably done more verbal appeals than I have written here. And I have won those now that I think about it with Michael's context. But ultimately, as I get into this, there's a lot of different techniques you can go through. I kind of decided to go through mine in a bit of a decision tree manner. And so first and foremost, one thing that I've learned as I go around the country with the small FSIS, small plant roundtables, is that people aren't always as fortunate as we are to have inspection staffs that are more working in a partnership than a contentious relationship. And so one thing that has been reiterated over and over again by the FSIS administration, the administrator himself, is
Sorry, we're having some technical difficulties. Denise, you are frozen. Can you hear us, Denise?
Oh,
there you go. You're
yeah,
back.
sorry. Am I backing up a little bit?
You're
I let
back.
my QA manager know that we won't respond or do a corrective action until we have something in writing. And that's for a lot of the reasons Michael has pointed out, is that I want to see the CFR. We want to read the CFR. We want to read their defense of why they think we're not meeting it. And then I'll decide if we agree or not. So that's one thing is, did the inspector provide the non-compliance record in writing? If no, then you ask for it. You let them know that you won't respond until you're able to review that non-compliance in writing. PHIS, Michael talked about a lot. It is a very valuable tool that I really encourage you all to, if you're not on the electronic PHIS system. A few years back, I made a little write-up to help someone figure out how to apply and get that permission. I don't know how that still relates to how you do it today. It's been a while since I've had to, but I'm more than willing to share it, with the caveat that it could be outdated, but it should give you at least a good jump start on how to go about that process. So for those of you, I didn't know what my audience would be. So some of you, this may not be the first time you're seeing a non-compliance record. For some of you, you may be not as familiar with them, but this is actually a non-compliance record that we had written that we ultimately appealed. So this is going to be the one that I come back to quite a bit throughout this. I tried to remain sensitive to names in here other than my own. This one happened a couple of years ago. It's forever known in our plant as Potato Starch Gate because of the ridiculousness of it. And basically, our second shift IIC was saying that we had spilled potato starch in our spice cooler, and that someone walked through it and created a 25-foot long path, and that was not okay, and we had to do a corrective action. There's a few challenges along the way with this one that I'll share, but ultimately when I received it on, you can see the date written was 1/19. I received it on 1/31. That was number one irritation, is I didn't find out about it until then. So basically, did you get it in writing? If not, require it. There is, I don't know if I thought I had, there is one thing where a challenge that there are situations where it's not in writing, but you have received the dreaded black tag, the US reject tag. And so at this point, it becomes a much more immediate need to respond, because that means that something isn't running on your plant potentially, and you want to get that going again. So again, if respectfully ask for a violation in writing so you can better understand the situations. That's how I usually word it. If I do kind of a litmus test on if I get a verbal notification of an NR and I immediately get irritated by it, not just because I'm having a bad day, but there's just something that doesn't sound right. That's kind of my gut check, to just take a breath. Don't get into it with the inspector at that point in time, but just respectfully ask for the NR in writing so you can better understand the situation. It's really, that's my method of de-escalating my emotions, my emotional response. If this involves a black tag, you may want to ask for the CFR immediately so you can look it up and start digging into it to get a response quickly and determine how you want to respond quickly. But you really got to try not to get emotional, otherwise it's just going to add to your problems. And I know that's a really hard thing a lot of times when it comes to NRs, especially ones that you're not completely agreeing with. So if it is provided in writing, then the next question you ask yourself is, do you agree? That's that gut check. Is there something that doesn't sound right, or can you hear it and you're like, okay, yeah, you got us. That does sound like something that could result in a food safety risk, or that does sound like a non-compliance to how we have our programs written. So that's like, yep, I agree, take your corrective action. I'm not going to get into taking the corrective action. That's the easy part. I'm going to lean more towards the no end of things. So similar to what Michael was saying, so this is the block 6 and block 10 that Michael was referencing. So do you agree, does the noted violation match the CFR cited, and is it relative to a real or potential food safety risk? So this is where you're doing your own homework. You have to be, you have to own the responsibility of your role in regulatory action and compliance. And so what I'll do is I immediately look at block 6, just like Michael alluded to. And what I do is I go and Google it, or whatever forum you like to search, web search you like to follow. And just as like, I've learned over time to kind of sort through the crap out on the internet, that anytime I'm looking up regulatory stuff, I add the FSIS to my search, as you can see on this example. That just helps kind of get me directly to where I need to go much quicker, and not having to sort through all the other stuff that might come up, or like blogs that come up where people think they might know what they're talking about, but they may not exactly know what they're talking about. So in this case, a lot of times I end up at the law.cornell.edu. As you can see below that, there's other decent sites. Actually, I went to the USDA one on this page, and it was the worst. So I wouldn't recommend that one. But the Cornell one, I peeked at the govregs.com one. That one looked pretty good too, but I just overall like the look and feel of the Cornell one. So what you do is, I'm going to the 9 CFR 416.2. It was part B, number 2. So this is the one that my inspector was citing. So I'll open up that and do exactly what, like Michael said, is I'll pull that CFR, and then I pull block 10. So you can see the inspector's description of our non-compliance in this situation. Basically saying that white powdered with footprints and scattered floor 25 foot long, the powder appeared to be potato starch. There's a couple of red flags there, and those, like Michael said, the facts. I thought, wow, that must have been quite the spill to go on for 25 feet. And I also was wondering why at this point in time this was a concern if it had just happened and it was on the floor, and our where this apparently happened wasn't in our production area, and potato starch is not an allergen. So there's a couple red flags there that I was a little bit leery on why this was an issue. So I didn't agree, and based on a couple of those, pulling those facts, there was something that didn't seem right. And I started asking some preliminary questions of the individuals that were named in the NR, only to find out that, you know, they were a little bit flabbergasted about the 25-foot long footprint trail. And so that's when I got into it. Now the challenge was this, I found out about this 10 days later. So the people named in the NR, I got a little, I did scold a little bit, like, you have to let me know about this, because now 10 days later I have to do an investigation and people forget things. So the sooner you can get to that investigation, the closer it is to that time point that the event happened, the better information you're going to be able to glean from everyone that is involved in that. So I investigated the violation. And so the investigation, some points that I looked into is, first and foremost, I directly went to interview the individuals mentioned in the NR. So I blocked their names out. Oh shoot, sorry. I blocked their names out in this, but this NR listed 2 individuals that were visually there to see what she was pointing out. And so I immediately went and interviewed those 2 people to get some more. From there, I learned there were more individuals that would have more information for me. So I think in all, I think I have this in the next couple of slides. I think I interviewed 6 different people to really understand what their perspective was of it. So during those interviews, I was asking how much was spilled, where was it spilled, how did it look like, did it look like someone stepped in it, how long was it there? I interviewed first shift, second shift, because this happened right at the beginning of our second shift. And then also, did they, what's up with the footprint thing? Because that one was really confusing to me. And then I myself was just reflecting on, is spilled potato starch on the floor outside of production area a threat to product? Is that, so based on the CFR, wall, floor, ceilings within establishments must be built of durable materials, impervious to moisture, must be cleaned and sanitized as necessary to prevent adulteration of product. I didn't see how this was putting product at risk. It wasn't even in a production area. Let alone it didn't spill onto any other ingredients. It wasn't an allergen, all those different points. So basically, based on what I learned, I chose to appeal the NR for a complete removal, not for a rewrite. And I went on to write and submit. So what I found in the investigation was that basically it didn't create insanitary conditions. From talking to first shift, second shift people, the spill was likely there for less than 2 hours, and it was actually a small spill on top of another potato starch bag that was like a little 3-inch diameter by 2-inch high cone shaped spill. It wasn't an allergen, and it didn't spill onto a non-allergen. There was nothing that was really flagging as a food safety risk. The 25-foot long footprint trail, that one was a little trickier because no one really knew exactly what was going on with that. And so I kind of went and walked the area, and what I found is that the footprint trail was actually, in fact, footprints from, we will throw a non-slip powder on slippery portions of our floor throughout wherever we have slippery portions so we don't injure anyone. And it was footprints from that non-slip powder. And I have pictures in the appeal. So I wrote that up into, I like to write, so don't feel like when I'll kind of show you my appeal, but I wrote an appeal in Word. I added some pictures of later down the road, the bag fixed and the footprints still existing because it's from our non-slip powder. And so what I did is I went into, this is where PHIS really comes in handy, kind of alluding to Michael's advice. This isn't, the appeal no longer exists, or the NR no longer exists, so I just took a screenshot of our current. And what you do is you go to your response, they're gonna have a written up one, and you can click on appeal, and then you can go ahead. So in my case, I had a Word document as the appeal, and so I just added that as an attachment, and then I went on to submit the appeal, and you sit and wait. I was going to show you. So, oh, where'd it go? Just real quickly. I don't know why that closed. I think I closed it. We were granted the appeal in this situation, and when that happens, the NR completely disappears. We just happen to have a electronic copy of that. So, you know, this is, I'm not going to go through word for word, but my first paragraph basically involves, you know, why I didn't agree, what my investigation, and that I don't agree on the basis of that I didn't feel like it was a risk, and it was not in sanitary conditions outside of reasonable day-to-day and process facility conditions. And then I went on, you know, it's a 2-pager. It didn't take much. And then I just went on to take pictures. These were like a week after the incident, or 2 weeks after the incident, showing that, you know, there are footprints because we use non-slip powder. So that's, I kind of rushed through that, I feel like, but for the most part, you know, taking that breath and not getting into it with your inspector is going to help you leaps and bounds to get towards, you know, a reasonable approach to your decision making and investigation and all that. So
Thank you.
I'm going to stop and let's do questions. Thank you all.
Awesome. That was really helpful to have that example of potato starch gate.
Yeah, I mean, still, like, I say potato starch NR and they're like, oh, potato starch gate. And I was like, yep. We were so irritated with that one.
That is hilarious. Michael, if you want to come back on with your video and audio as well, I'm going to run through some of the questions that have come in. So some have come in through Q&A and in chat, so I'll go through all of them. Well, first of all, in Q&A, Bob says, Dr. Fisher, I am fascinated with your approach. So not a question, but just fascinated with your approach. You have anything to say to that?
Okay, I tend to be a little more legalistic than practical, because a lot of the NRs I deal helping people with are more HACCP design issues, supporting document issues, and they don't get resolved at the district level, or definitely not below the district level. So I'm helping write appeals for headquarters or to headquarters. So you really have to split hairs. And so, yeah, I tend to be legalistic, and my brain runs that way anyway. So
It's probably why.
And I go scientific because that's what my training is. We joke because we have the same kind of people in within our facility, where we have a lawyer, an attorney, and then we have the scientist, and we laugh about how we both approach them very differently. So, but they both work. So.
Yeah, it's nice to have both of those frameworks. Okay, some questions that have come in. Bob asks, does going after the FSIS inspector so specifically cause undue friction with our inspector? Is this a concern that should be part of our decision in appealing? What do you guys think?
It happens, all right? But never forget, you're dealing with a federal bureaucracy, all right? Yes, you're dealing with a person, but they are a representative of a federal bureaucracy. It is not uncommon to find that, pardon me, that an inspector may actually disagree with why they're writing you an NR, or why they're doing something, all right? But they're doing what their employer tasks them to do, all right? They're doing the job, all right? Just like everybody else does. Doesn't mean you agree with it. It's what the boss wants. So emotions do get involved in this, and yeah, it's easy, you know, Potatogate, it's easy to get really emotionally involved when this harmless white powder on a floor in a non-product area results in your entire plant being shut down. And some inspectors will hang a tag on the front door for something like that. And yeah, it gets really emotional. And like Denise said, you got to step back, turn around, close the door, scream, hit the wall, and then open the door again and then continue, because being emotional during these things is just not in your best interest.
Mm-hmm. Denise?
Yeah, I would add to, so I don't think it should, I think you should definitely be aware of your relationship with your inspection staff, and it shouldn't stop you from appealing something that you don't believe is proper. It should be part of how you evaluate how you're going to appeal. So, you know, we have a good relationship with our inspection staff. I don't always agree with our IIC, but I respect his knowledge. If I didn't have a good relationship with my IIC, I'm guessing a lot of those verbal appeals would have been written appeals. I would have just been quiet, told him to put it in writing, and I'll answer it, because I probably would get more grumpy to his face if I didn't know how our relationship worked. And there's days where I'm not in the mood for him. And those are days where I say, just put it in writing because I don't agree with you. And then he'll sometimes second guess, or not second guess, but he'll reevaluate his stance. If he knows that I'm saying that, he knows that maybe he should step back. But again, that's because we have a very well-established relationship and respectful relationship. Ultimately, if you don't feel like you have that level yet, I would just do the whole take a breath, say, you know, I'm not really understanding this. I'm not seeing how this is a problem. So please just get it in writing so I can investigate more. That's usually my kind of standard response if I'm not agreeing. That gives them a little bit of a heads up that, hey, this doesn't sound right, and I'm not like just taking this. But it keeps it tamped down from people getting grumpy and starting to have a, you know, for lack of a better term, pissing contest right there. Like, stay out of those, especially if you don't have a great relationship. Sometimes for fun, if I'm in the mood and I see our inspector is, we'll do that for fun. As long as I know it's not going to end poorly. It doesn't always work out for me. And I haven't always been perfectly compliant with my own advice of keeping it emotion free. So I'm not innocent in that. But for the most part, I've learned, wisdom has taught me, breathe.
And the appeal process can actually be a good relationship builder and a learning platform, because it forces both of you to figure out what their problem really is and get it right. And as far as relationships go, when the inspector or the inspector supervisor figures out that you're going to push back, all right, you're going to force it to be right, or figure out what is right, even if you're wrong, they step back. They think twice about filling out that NR and handing it to you. They think twice about just simply telling you no.
Mm-hmm. All right, thank you. Next question for Michael. I heard you teach an online course at Johns Hopkins University in the MS and Food Safety Regulation program. Do you cover the information you shared today in that online course?
Slightly, but the course I teach at Johns Hopkins is really about the regulatory process, sort of at a higher level, you know, and a lot of the background and the thought process of it. I mean, the purpose of the course is not to dig into the details of writing an SSOP or, you know, specific regulatory requirements. But it's basically the same information I share with people anywhere, in an email, on the telephone, and the listserv postings. Mm-hmm. And I'm even working on another project to, basically I'm trying to write a book online and capture all this stuff. So when I'm not around anymore, it, you know, Rebecca can have it.
All right. Dr. Fisher provided a link here in the chat box to govinfo.gov for official current regulations. And this is the gold standard when referencing a regulation. So make sure you check that out. He also mentions that adding images to your appeal text goes a long ways to providing a preponderance of evidence to your appeal. I don't see any more. Oh, here we go. There's another question in the Q&A. Would either presenter comment on answering an NR that has to be written by the implant inspector based upon the demand of an EIAO during an FSA? There's a lot of acronyms there. So,
Okay.
Michael, you want to start?
Yes. All right. An EIAO is an FSIS employee who basically works for the district manager, and they're sent out to the establishment to be the eyes and ears of the district manager and report back to the district manager. Now, while they're in the plant doing their job, they often find non-compliance, all right? But the EIAO is not the inspector assigned to the establishment. It is not their job to write NRs. And so when they find a non-compliance, they typically inform the assigned inspector of the existence of this non-compliance. And it is really up to the inspector whether they choose to issue an NR or not. The EIAO cannot direct it to be done. All right? The EIAO is not the inspector's supervisor. But the inspectors will typically issue the NR. Now, when the NR is based on records, there's a record that wasn't kept right, that's usually pretty simple to deal with. When the NR is based on something that the EIAO observed, but the inspector did not observe, that gets a little trickier, all right? That's like the policeman showing up at your door saying he's going to write you a speeding ticket because some third party saw you speeding on the highway last week. And so what a smart inspector will do is, particularly if the EIAO tells them something, they'll go look at it. So when they write the NR, they're writing the NR in first person. They're saying, I observed X. Where people get upset is when the Block 10 narrative starts out with, EIAO Smith saw this on Tuesday and told me about it. All right. That becomes problematic.
Denise, do you have any thoughts on that?
I can speak to this really mostly about a year ago. We had an FSA in our RTE, and naturally the FSA resulted in a couple NRs. And so the EIAO wrote those, and like Dr. Fisher said, those can be tricky. And especially, we were all in the same room when the EIAO told us, by we, I mean our PHV and I don't think our IIC was in there. My food safety manager was in there, and we all heard it. My food safety manager and I had heard it more in context with the EIAO, and so we understood what he was getting at and needed, and so we got it. The challenge came when our PHV came to follow up on the NR, and we had answered it according to our understanding with the EIAO, where she hadn't been present for some of that context, and she was expecting a completely different response. And I'm sorry, I can't exactly remember how we pushed. We pushed back. I think it was more in regards to getting our EIAO involved in the conversation that administered the FSA. I think that's what we did, is we pulled him into the conversation, or encouraged her to reach out to him for clarification, because that's how we understood it. Another great avenue that I had on one of my slides, but I didn't point it out, is Ask FSIS is a great resource. If you haven't used it, it's not only just a resource to search, so you can just search topics on it. It's also a forum where you can submit your own questions. One thing I would caution, if you submit your questions to Ask FSIS, if you can avoid any kind of alluding to the fact that you're trying to settle a dispute, don't put that in your, just remain very straightforward to the fact or the question of regulatory that you're asking. So we'll usually go to that if we have something pending or something we see coming forward and we'll be very specific to our circumstance and the regulation we're looking at. But if it's relative to, hey, I don't agree with my PHV on this, can you be the referee? They aren't going to give you the answer you want. They're going to tell you to go work with your, but if you say, here's what my understanding, here's what we're doing, is this okay? That's typically how I stick to Ask FSIS, whether I'm in a dispute with in-plant inspection or not. That tends to get you a bit more clear-cut answer from Ask FSIS. So I went a little bit in different directions there, but yeah, it can get hairy, but I would seek out EAIO. You can still contact them, or encourage your implant inspector to clarify with them, because this is how I understood it. Is that how they understood it? Trying to get that dialogue. And FSIS, whenever we've had our roundtables, has always encouraged that 3-way call or 4-way call or whatever. Everyone get on a phone call together. That's another good way to get everyone on the same page, including yourself. So if you misinterpreted what they were trying to say, and now all of a sudden you're like, wait, it's best to do that as a group. And again, easier said than done when you have a bit more challenging relationship with your implant inspection. We also have to realize, is that a real contention or is it a perceived contention just because they're enforcing regulatory, and that's irritating sometimes.
And I'd like to say, having spent probably at least 10 years being that person on the other end of Ask FSIS, you're dealing with the Office of Policy, not field operations. The people that answer those questions are pure bureaucrat. They're in pure bureaucrat mode. They are trained and instructed to not say anything controversial, not say anything that reflects poorly on FSIS. They are not judges or referees. And here's another sort of unknown, unofficial policy within FSIS. Even though the Office of Policy may make a statement, the Office of Field Operations is under no obligation to comply with it. So you may get an Ask FSIS response that supports your position with the inspector. The inspector is under no obligation to consider it.
But most reasonable ones will.
Yeah. Yeah, if it's about facts.
Yes.
All right. And
yes.
that's why Denise and I both keep talking about the facts.
Yep.
I had a question from someone who couldn't attend this morning, but they wondered about appeals on humane handling NRs. They're under the impression that they rarely grant those appeals. So what's your experience, Denise?
I think back to the NPAN back and forth from a couple of years ago. I was actually reviewing that last week for some reason. And Michael, I remember Dr. Fisher, it was one of my first interactions with him, jumped in. And because my question was, has anyone ever actually appealed a humane handling? NR maybe, but the situation where your knockbox is black tagged and you just need to get going again. And I remember Dr. Fisher's response being, I don't know, I am not aware of anyone ever appealing a humane handling. And it was a long back and forth, and a lot of it went down to that timing. If you're facing a suspension, then in most situations, you want to get back up and going as soon as possible. In our situation, we have animals coming in every day. We're killing, 45, we were at 45 head, now we're at 100 head, and we can't afford to be down tomorrow, because where are we going to put the load that's inevitably on the way for tomorrow? And so I'll let Dr. Fisher kind of add to this, because I'm sure he's got more thoughts. There was that conversation of like a retroactive appeal. So go ahead, answer it, get you going, but then appeal. But that's really kind of, it's annoying. Yeah.
Yes, the difficulty with humane handling is you're dealing with the Humane Methods of Slaughter Act. All right, not specifically the Federal Meat Inspection Act. And humane handling is extremely political because of the animal rights lobby. All right, FSIS is afraid of them, okay? And, it's much easier for FSIS to deal with an upset establishment owner because they have regulatory authority over them. They don't like getting, dealing with senators and things who are side with the animal rights folks. And you need to understand that the animal rights world basically has an open FOIA request for every NR that is written for a humane handling regulation. So they see every one of these and they follow up on them. And if they do not see FSIS aggressively pursuing compliance and leaning on these establishments to do something, then they engage their political arm and deal with FSIS. And so it's really, politically in FSIS's best interest to be hard on the establishment because it creates the least problems for FSIS as a bureaucratic or a government agency. The best solution for dealing with humane handling issues is to really understand how your establishment works, get procedures in place, practical procedures in place that work in your establishment. And then as the manager or the supervisor, don't just think, oh, I got something on paper. Yeah, they'll be happy. All right. They're happy that you've got it on paper, but as soon as something goes wrong, the weight of the world falls on you. And so you may have it on paper, but you have to make sure, that from Denise's chair, she has to make sure that it's being done right. Now, when I say procedures in your plant, I deal mostly with little plants, and every one of you guys does things somewhat differently. You have different employees, geography, weather, all of this stuff. And so you're really trying to fine tune this thing. How does it work for you? And then make sure that happens, all right? And then have a record keeping system for doing it. All of these things I just described, none of them are required by regulation or statute, all right? It's all driven by this, sort of political force. And the fact that the Humane Methods of Slaughter Act says that you have to render the animal insensible to pain with a single blow. That's the word, single blow. So the statute says you get one shot at it. So when it takes 2 shots, you get an NR. And the Humane Society of the United States is looking over the shoulder of FSIS to make sure they did something.
Thank you, Michael. Do you have anything, Denise, to add before we close?
No, I think that pretty much sums it up.
Yeah.
I have hours worth to add to the humane handling topic.
That could be a whole other webinar.
Yeah.
Right. Well, I really appreciate Denise and Michael's time today. I learned a lot. This is recorded and will be uploaded to our YouTube channel by Friday, and then you can share it with colleagues or watch it again. And until next time, thank you for joining us.
Thank you, everyone. Yep.
Thank you.